What happens if you die today? What are the legal implications for your loved ones and your estate? Introduction. When a family member or friend passes away, it is an extremely traumatic experience for that person's loved ones that are left behind. In most instances, a loved one or a close family member will wish to attend to the affairs of the deceased or be appointed as an executor. Difficulty experienced by these parties is that they are not well versed in the administration of deceased estates and will in the end require the assistance of an attorney or accountant. Kindly note that in these circumstances delays can occur in finalizing the administration of the estate. Starting point. The first question that needs to be answered is, did the deceased have a will? The reason this question is asked is due to the fact that the answer determines which legislation we will need to follow when it comes to the administration of the estate. Should the deceased have had a will, then his/her wishes and bequests made in terms of that will shall be adhered to in the administration process, with the executor being tasked to fulfill their dying wishes. However, should the deceased have passed away without a will being in place, the Interstate Succession Act No. 81 of 1987 will apply. What are the benefits of having a last will and testament in place? Number 1. The beneficiaries of the deceased estate are easily identified. Number 2. An executor is appointed by the deceased in terms of his or her will. It is always a recommendation that an attorney be appointed in the will. Number 3. Kindly note, if an estate's value is over 250,000 Rand, the Master's Office will insist that the assistance of an attorney or accountant be obtained. Number 4. The administration of the deceased estate is simplified as the deceased wishes are clear and unambiguous. Challenges experienced when there is no will in place. Number 1. The Interstate Succession Act will be applicable. Number 2. The beneficiaries are determined by law. The normal course of this is spouse, children, grandchildren, parents, siblings, alternatively the next blood relative. This will be explained in the slides that follow. Number 3. The immediate family will nominate an executor to administer the estate. Number 4. The master will endorse the nomination or not and will seek security, bond of security to the equivalent value of the estate in certain scenarios. Number 5. The requirement of security can be prevented by having a will in place. Surviving spouse, no descendants. If the deceased is survived by a spouse and has no living descendants, the spouse inherits the intestate estate. If the deceased was a husband in a polygamous marriage, the surviving spouses inherit in equal shares. Descendants, surviving spouse. If the deceased is survived by a descendant but not by a spouse, the descendants inherit the intestate estate, and where any descendant has predeceased with issue, such issue shall inherit that predeceased descendants' share per stirpus. Surviving spouse and descendants. Where there is a surviving spouse or spouses and descendants, each spouse will inherit 250,000 Rand or a child's share, whichever is the greater. The children will inherit the residue if any. If any child is deceased and is survived by descendants, such child's portion will devolve on his or her descendants per stirpus. No surviving spouse and no descendants. If the deceased leaves no spouse or descendants but is survived by his or her parents, the parents inherit the intestate estate in equal shares. No surviving spouse, no descendants, one parent predeceased. If the deceased leaves no surviving spouse or descendant but has one surviving parent, the surviving parent inherits half the intestate estate and the descendants of the deceased parents the other half. If there are no descendants of the deceased parent, the surviving parent inherits the entire estate. No surviving spouse, no descendants, and parents predeceased. If the deceased leaves no surviving spouse or descendants and no parents, but is survived by descendants of the deceased mother and descendants of the deceased father who are related to the deceased through such parent, one half of the estate devolves on the descendants of the mother and one half devolves on the descendants of the father. The descendants take per stirpus. No surviving spouse, no descendants, parents predeceased, and no descendants of one parent. If there are no descendants of one of the parents, the descendants of the other parent inherit the intestate estate. No surviving spouse, no descendants, parents predeceased, and no descendants of either parent. If the deceased is not survived by a spouse, descendant, parent, or descendant of a parent, the other blood relations of the deceased who are related to him nearest, in degree to the exclusion of those more remote, inherit the intestate estate in equal shares. No living relatives traced. Where there are no known living relatives, the proceeds of the intestate estate are paid to the guardian's fund, and if no claimant within 30 years, the intestate estate is forfeited to the state. What steps do I need to follow? The estate is reported at the Master's office in order to have the letter of executorship issued. NB. No dealings regarding the estate of the deceased is allowed before an executor is appointed. An advertisement, in terms of Section 29 of the Act, is placed in the local newspaper and the Government Gazette for a period of 30 days for debtors and creditors to lodge their claims against the estate. Valuations of movable and immovable assets vesting in the estate are done. An estate-led bank account is opened by the executor. All funds due to the estate of the deceased will be paid into the estate-led bank account. Estate duty return is submitted to SARS, only applicable if the net value of the estate is above 3.5 million. Finalization of the liquidation distribution account. Explained, a liquidation distribution account is a breakdown of the assets, administration costs, liabilities, and distribution of assets to the beneficiaries. The liquidation distribution account is submitted for approval at the Master of the High Court. After approval of the liquidation distribution account, the account lies open for inspection for 21 days at the Master's Office and Magistrates Court in the area where the deceased lived for longer than 12 months before death. Distribution of the estate to the beneficiaries in terms of the liquidation distribution account may occur. Q&A. Question. What happens to the inheritance of a minor child if there was no will in place? Answer. The inheritance of any beneficiary under the age of 18 years will be paid to the guardian's fund until they reach majority. Question. If the deceased was married in community of property, what are the implications? Answer. When married in community of property, the entire estate must be administered in the event of death. For example, this means that even if the surviving spouse has assets only in his or her name, those assets must still be mentioned in the liquidation and distribution account. Q&A. Question. What happens if no beneficiary can be located at the time of distribution of the estate? Answer. If there is no beneficiary, the inheritance will be paid to the guardian's fund. Should no claimant arise in 30 years, then the inheritance will default to the state. Question. Am I allowed to exclude my spouse or child in my will? Answer. Yes, you are allowed, as in South Africa we have the right of freedom of gestation. Question. Are beneficiaries entitled to inheritance before distribution of assets? Answer. The answer is no. Should the executor pay out monies to a beneficiary, he can be sentenced to imprisonment or a fine or both. Q&A. Question. Can beneficiaries decide to trade assets with each other? Answer. The beneficiaries can enter into a redistribution account wherein assets are redistributed between the beneficiaries. However, same must be approved by the Master's Office. Question. If the deceased passed away many years ago, what must be done? Answer. The estate must still be reported and the standard administration process will still be followed. Question. What does it mean when the Master's Office requires a bond of security? Answer. The Master's Office can insist that the executor provide them with bond of security to the value of the estate, which is a security measure in the event of misappropriation of the inheritance by the executor. Thank you for your time. We hope that you found the talk informative. Should you have any queries, please feel free to contact us anytime. Telephone number 011 867 0119. Email cattorney@bothacopo.co.za or estates@bothacopo.co.za.